Hello, everyone. Welcome to Medicaid Monday, our September version. And this Monday, we're going to be covering a topic that is something yet to come. It's the look back and penalty rules with regard to Medicaid home care, which currently we do not have in New York State. So we're going to cover that topic. Please know that there are no final regulations yet, final rules with regard to the implementation, but we want to give you a heads up on what's coming and what clients and your constituents can be doing now in order to plan in advance for Medicaid home care.
Hold on. There we go.
So this is our agenda, the proposed rules. And remember, these were enacted back in 2020. And they are pandemic rules that got delayed due to the public health emergency. What's the latest word from the Department of Health? What the changes mean to you? The issue of unknowns, and I harken back to our old friend Donald Rumsfeld. We know what we know what we don't know, but we don't know what we don't know. And I think there's a lot of third tier knowledge that goes along with these rules right now. But we're going to try to give you as much as we have and project out what we think is going to happen if the rules do in fact become implemented. The next 3 months, what we're doing in terms of this program, opportunities for individuals who want to age in place. I think that is really the holy grail and what we all strive for, something that we all advocate for, and then some legislative initiatives that have gone absolutely nowhere to try to change these rules. So Frank?
Sure. We got to do a recap of the numbers just like we do on every Medicaid Monday. So again, if this is your first time watching, when you're dealing with Medicaid, you have income rules, you have asset rules. So income rules are now on the screen. So if you're one person at home wanting to get care in your house, which is kind of the point of today's webinar, talking about people that want to stay in their home, you get $1,752 a month of income. If you're a married couple, it goes up to $2,371. And then we got the spousal income allowance of $3,853.50. And again, not that it's going to apply today, but if you are in a nursing home, your income allowance is that whopping $50. Been that way for a long time, still hasn't changed, not likely to change under these new rules. And then we have your assets. Again, one person, countable assets, $31,175. Couple does not double, only goes up to $42,312. We have that community spouse allowance of $74,820, which has been at that number for quite some time now. And we have our spousal share number right at the bottom, which again, we did a whole Medicaid Monday about how spousal rules work back in February, I believe. So we have a lot to get to. So let's talk about better things than this. So whenever we're talking about Medicaid, typically when we're discussing this, we have chronic care rules, we have nursing home rules, that's your chronic care side. And then you have your community rules. That's your home-based community services. You have your assisted living, your adult daycare, your managed care. Those are the subject of today. That's the subject of all these changes with these new rules and the potential look back. So we're going to be looking on what's on the right side of this of the screen right now,
So
not the left hand side.
before you flip, and I know we have a lot of slides to cover, but it's important to keep in mind that as we're doing Medicaid planning for home health care, there are income rules and there are asset rules. And Frank gave you the $1,752 per month for an individual. We'll focus on that for now. Married couples have a little different rules. But $1,752, if your income is over that, right now you have an opportunity to shift that income into a pooled income trust and to be Medicaid eligible for all of your services. On the asset side, you right now have an ability to transfer assets to get below that $31,175 and to be eligible for all of the Medicaid services. There is no waiting period. People still do not understand that you can do all of these same transfers today and be eligible, because it's a first of the month gig, be eligible on October 1st. That's called the snapshot date when all of these asset and income rules are analyzed. What we have found over the last few years is that the state has changed a lot of the other rules. And we've gone through them at great length, the New York independent assessor process and all the things that have delayed and put in place very, very painful 5-6 month waiting periods before people get services in the home, if they can find them. So the financial eligibility rules, Frank, up until now have been very clear, but the clouds are on the horizon.
Yeah, and it's been that way since 2020. And if all these potential rules go into effect, it really could muddy the waters on what we're able to do, how fast we're able to do them, and kind of the tools that we need in our toolbox, which we're going to try to go through those quickly without making your head spin around too bad later in the presentation. So the law, the effective date was supposed to be October 1st of 2020, but again, that has been permanently extended up until now, up until they decided that they wanted to implement them. So because there are federal rules at play, there are local rules at play, the best we know is that implementation will be sometime in 2025. Just because of kind of the logistics, it's likely it wouldn't be until at least the start of the second quarter. So that would be April at the earliest, if not then April, then July. So just so again, like Lou said, a lot of things up in the air with this, and I don't think we've had any kind of updates from the state as to when they're thinking about when implementation would happen. But if it's going to happen, it's still not until 2025, most likely at least April or July of 2025, if it's implemented at all.
As we're going to see, there are a lot of details and administrative difficulties in implementing these new rules. And I think that's part of the state's dilemma, is how do we actually enact this so that counties, because remember, this determination is made at the county level. So the 57 departments of social services, and I'm guessing some of you are on this line today, and HRA in New York City will be having to do this intake, this examination, a 30-month look back period, the implementation of a penalty period, and the interpretation of when that penalty period expires. No mean feat. Trust me, when we see these rules as we're going to lay them out, this is not an easy exercise. Everyone is looking for the smoke signals coming out of Albany from the Department of Health. When is this actually going to take place? And as we're going to talk about, there is a lot of advocacy to prevent this from taking place for all of the reasons we're going to state. But this is very much something that is out there. It's on the horizon, something we're preparing for and trying to prepare our clients for. So hopefully today's presentation will be useful to each of you.
So what programs are impacted? It's a lot of the home care programs that you've either heard us talk about or that you're familiar with if you're in the field. So your personal care services program, your CDPAT program, your private duty nursing, your ALP programs, and then most likely then also would be your MLTC programs and your PACE programs. So essentially the vast majority of what we just call generally community Medicaid, they're all in those first 5 bullets. The ones that, again, as far as we know, not impacted by this would be your waivers. So that'd be your TBI waiver, your traumatic brain injury waiver, your OPWDD waiver, your nursing home transition diversion waiver. So it's entirely possible that if we do see implementation of these new rules, it's going to put even more pressure on the waiver programs because people may then have no other choice but to apply to a waivered service program to get around the look back or the other issues that are presented by trying to get into one of the other services that we've listed here.
And as you see there, the last real information session we had with DOH was over 4 years ago. So we're using the rules that they gave us back then and assuming that they're going to keep them consistent for implementation now. So the programs that are very important, we work with OPWDD very closely. So opting out in terms of the state TBI waiver, nursing home transition diversion waiver, and 2 of these you have a choice or no choice on. If you're going to the TBI waiver program, that really is something that you're going to have to use because of the unique services provided through the TBI program and the OPWDD program, which are wonderful services. Nursing home transition diversion waiver, Frank, you have an option you can opt into.
Yeah, there are plenty of times where we have discussions with clients about whether it makes more sense to go to the waiver or whether to go to MLTC and kind of go more the traditional route towards long-term care, or if you're fortunate enough to live in a place where you can get PACE, right? Maybe going to PACE and getting those services under kind of one umbrella. But again, if the rules are going to be different for which program you pick, you may not have as much of a choice as maybe now that you do.
So if people get caught in the conundrum of having assets and needing to get services right away, it may lead us towards more nursing home transition diversion waiver application.
Right, exactly. So quickly, what we have seen some changes already. So obviously the New York Independent Assessor, which we've done quite a bit of education about, we've already been seeing that, dealing with the issues that come with that. And we've also seen like the other parts that accompany that, like your independent review panel, your independent physician assessment, your community health assessment that's given out now. So, all kind of the medical side of this that we've seen, those were already changes that were supposed to be happening and then actually were implemented. So we're not really talking about those today because we've done past programs on those and because they're already here. So biggest change, right, is this potential financial change with the implementation of a 30-month look back. It would require that all applications that are submitted be accompanied with 30 months of financial records. And then they would be audited, just like we see now in our nursing home cases with our 60-month look back. And then there would be a potential calculation of a penalty period and a period of ineligibility if gifts or transfers are found within that 30-month period of time. That's exactly like what a nursing home application currently looks like. It's just for half the amount of time. As Lou said, implementation-wise, process-wise, what does this look like for the counties? Because I can tell I can tell everyone on the webinar pretty strongly, all the counties that we're currently dealing with, I have not heard one of them say we have so much staff that it's, we just have hands waiting for more paperwork. Everyone is working very hard. A lot of offices are understaffed right now, before any of these changes happen. So if we get to the point where every application has to have 30 months of financial records in place with it, regardless of whether it's community or then 60 months still for a nursing home, just the amount of additional paperwork and pressure this will put on the counties will be, I think, pretty staggering for them. So
there are a total of 111,000 nursing home beds in the state of New York. And right now, the census, I believe, is somewhere around 98,000 residents of nursing homes in the state of New York. If people cannot get nursing homes and you have to then go through this process and they can't get home health care either, where does it place the person, the family, the individual who wants to get services in the home when they are in this period? So navigating the period, the penalty period, and finding ways to spend down is one of the more difficult exercises that we're going to go through here. But waiting out that time period and how do you pay for services during that time period is a critical element for any application. And we're going to talk about something called the rule of halves, which in a nursing home case, you can gift half and do a note transaction and preserve about half the assets. Much more difficult in a home care setting.
It is, which we're going to try to lay that out. Like there's a lot, but we're trying to lay that out for you. And the other big change that was rumored was this medical change, where currently you needed assistance with more than one ADL, so you needed two, right? And then they were talking about upping that, so now needing more than two, so now you need at least assistance with 3 ADLs, and also increasing the criteria with person that has dementia or Alzheimer's. So currently now it was at least, you would need supervision with at least 1 ADL. Now it would be more than 1, so at least 2. So they're not only making it harder financially speaking because of the 30-month look back, but they're also potentially increasing the amount of assistance that one would require to medically qualify for help.
And oh, by the way, the Consumer Directed Personal Assistance Program is set to undergo major changes. We had a lot of this discussed at our Elder Law Forum in May, and CDPAP, which right now has about 600 agencies administering it across New York State that are in the communities and dealing with families and people and helping them through this process, is supposed to go to one agency that's going to cover the entire state of New York. And there are only 2 agencies in the country, we understand, that are eligible for this because of the way that the requirements have been structured. You have to be running one of these programs statewide in another state. So that's down to 2. So we're waiting to see. There's litigation that's been filed, there's advocacy that's going on. And in all of these cases, folks, advocacy helps our clients, helps your constituents. And the legislators are in a position where these are very complex rules with very large budgets. So unless voices are heard in Albany, this goes right on without having a fight that needs to be fought. And so imposition of home care rules, we think, is going to exact serious penalties for people who want to stay at home, just like the CDPAP rules.
So just to kind of give a sense of kind of what this looks like, so just to see how it's calculated, if you're making a transfer of $158,820, if you're in the Capital District like we are, right, you just do the math. So you take the amount that's given away, you divide it by the penalty number, which in this case for this region is $13,235. That would result in a 12-month penalty without Medicaid. So you'd have 1 year ineligibility because they found transfers of $158,000. If you do all this before the implementation of the new rules, so before next year, there's no penalty, right? Well, like Lou said, like we've said many times, there's no look back for home care. There's no penalty for home care. You just get your services. As soon as we can get your application approved, your services turned on. But if you put your application in with this penalty after the new rules, that's where your 12-month penalty hits. And then again, kind of in the weeds of kind of know what we don't know, kind of don't know what we don't know. Finding out when this penalty runs is kind of also a question, because currently your penalty runs when you're otherwise eligible, you're spent down, you're in a nursing home and you apply. That's generally when we're worried about a penalty running, because it only applies to nursing home cases. Well, when did you become eligible for needing home care, right? Is it the second you started paying for care? Is it when Medicaid approves you? Is it some other time? Do you need a doctor to say? We don't really know that answer. Hopefully, as more of this comes out, maybe we will get some more knowledge as to when does your penalty actually start running if you have a penalty.
It's one of the major questions, and if you think about it, people applying for chronic care Medicaid are in the nursing home. By definition, they have to be. You cannot file your application and start the penalty period running without being in the nursing home. And so when you're at home, you're at home. Are you eligible? Are you not eligible for home care services? Who's going to come into the home and perform that assessment? Right now, all of the assessments for Medicaid are done virtually. Virtually all of them, not all, but virtually all. You have the right to an in-person. But are they going to be able to do this from the perspective of qualifying people for home care services on this eligibility run? I would imagine, Frank, it would be NIA that would be going out and doing this initial eligibility determination, but that's what's going to trigger your penalty period.
Yeah, so it's like, are we gonna have to have another assessment just for this purpose? They're gonna be able to rope it in with one of the other ones? Don't know, right? We'll have to wait and see. Just to kind of refresher on the regional rates, they're all here on the screen. Again, they get updated every year. So this would be the number that you'd be using to figure out your potential penalty, just depends on where you are. One question we were dealing with a lot when all these rules were originally discussed was, will the look back be retroactive? When would it start? So when we were talking about this in 2020, we were talking about as once we got to October, it was going to be phased in. So if you applied in October, you'd have a 1 month look back. If it was November, it was a 2 month look back. Well, now we're 4+ years or almost 4+ years out of when it was supposed to start. So now we're past 30 months. And now again, best as we know, when you go to apply, once they implement this, the 30-month look back will just be 30 months from the month that you apply, going back a year and a half from that. So again, could change. That's what we think. That's kind of our best guess. We know.
And will it be retroactive is another question.
Right.
Will people who are already approved for Medicaid home care and already on Medicaid home care have to go back, and if there have been asset transfers, somehow face a look back and penalty period?
Right.
And we don't think so.
Yeah.
They basically said, and logistically, it would be virtually impossible for the state to go back and address this on recertification or any of the other ways that they might go about trying to invoke a penalty against someone who is already receiving benefits. I just don't see that as being practical, and I don't believe that it's the DOH's intent to make it retroactive.
Correct. So what exemptions do we think are still going to apply? Well, a lot of the ones that we've been using for a long time. So if you transfer to a spouse, it's typically exempt. A blind or disabled child or a trust to benefit them, it's exempt. Or if it's a sole benefit trust, exempt. So if they still work the penalty the same way that they have for nursing home, these are all exemptions that apply even if you're in a nursing home. So there's no reason they wouldn't technically apply to a new home care look back as well. So we may lose our ability to do things quickly, but we won't lose our ability to do planning. It's just a matter of what circumstances we can use them.
And many of you are thinking right now, I am guessing, that, oh, pooled income trusts can also receive other assets because of the way that pooled trusts have been treated without any penalty period.
Right.
We're going to talk in just a few slides about how the pooled trusts may change and what that's going to look like with regard to both income and asset transfers into a pooled trust.
And then we also still have some remedies that even if you do, or if you are found to have given something away, there are other remedies that we have. So if you got full market value for them, then it would not be typically held to be a transfer as long as you can show that you got full market value. If you gave something away exclusively for a purpose other than to qualify for Medicaid, that also is not something that would result in a penalty for nursing home cases currently. So it might lead to a lot more litigation and a lot more fair hearing to try to figure those points out. But again, if the exemption or that ability applies to nursing home, it should apply to home care cases as well. Or that last bullet, if you've actually gotten it back. So if you've transferred something, but then you got it back, well, if you get it back, it's not a transfer anymore. You then create potentially a new asset problem because now you have more money or more assets than you had because you got something returned to you, but at least that would cancel the penalty out. And again, it's the burden of the person applying for Medicaid to make these determinations and to provide the proof as to either fair market value or transfer for purpose exclusively other than to qualify for Medicaid, because if you don't, it will result in a penalty period.
Now, we've had these rules for nursing home Medicaid for years. Think about it though, going over into a home care context, we basically had a free ride.
Yeah.
Going in, you could have paid aides in cash under the table. You could have done all the kinds of things that people do as they're going about life and going about getting care in the home that could now result in a penalty period. So one of the keys to this and any Medicaid topic is you gotta have receipts. You need to bring receipts. Don't pay in cash. Make sure at least you have a canceled check, if not putting them on a payroll that is fully in compliance with all the laws, including taxation, workers' comp, unemployment, et cetera. If you're going to have transfers to children who happen to be providing services, get a personal services contract and have a contract that is binding, that can be used to have assets go and income go to a child to pay for valuable services. Those kinds of things do work in a home care context. We're assuming they're going to continue to work. So proving what you have is better than knowing what you have. And that is really the law.
Yeah. And then transfer to home, right? The home is always a special asset. So we still have our homestead exemption transfers that are always exempt to a spouse, to a minor child, to a certified blind or disabled child. If you have a sibling with an equity interest for at least a year immediately prior to institutionalization, that's typically worked for a nursing home context. And we have our caregiver child that's resided in the residence for 2 years prior to institutionalization. Those have also worked, but as you can see in the highlighted portions, those are dealing with institutionalization, where if we're talking about home care context, well, then we don't have an institutionalized person. So one of the outstanding questions we have are, would these exemptions then be expanded to then include, 2 years prior to needing home care, or, sibling that was in the residence at least 1 year prior to needing home care? We're not sure. Hopefully, there'll be some clarification on these. Spouse, minor child, disabled child, no reason to think those won't apply. But these other ones, again, so we have some things up in the air because these don't really apply super well to a home care context.
And some of the Medicaid programs have a standard of otherwise nursing home eligible.
Right.
And I would assume that if you're otherwise nursing home eligible, these same exemptions should apply and the
Right.
same rules should apply.
Pool trusts. So, Lou, do you want to take this one with the kind of the history on the law here?
Sure, there they are. They're on the screen.
Yeah.
So you have all the pool trust case law and over 93, which brought in pool trusts. They're statutory trusts administered by a not-for-profit. You had New York State then do an administrative directive. That's the 96 ADM8, the GIS, General Information Services Memoranda. And so we've had this litany of pool trust cases and rulings right through to the point where you can transfer assets and income to a pool trust if you are in home care. But the basis of all of those and all of those cases is that there's no penalty period for home care. Well, now there will be. So does all of this change? And now a transfer for less than full consideration into a pool trust, is it treated as a transfer of assets or does it maintain the exemption?
We don't know. So the informal position that we've been told, unfortunately, is that it may get to the point where when you make your pool trust contribution every month, that then you either have that then all that money has to be used for that person within that month. And any money that's remaining in that account at month's end will be treated as penalty or potential penalty, because then you've given money away, you've not gotten full value for it, you haven't used all of it. So that would be a substantial change to how pool trusts operate, because up until now, again, because there's no transfer penalty, if you had money that built up in your account at the end of the month, it would just roll over to the next month and it's there for you to use going forward. So this will be a big piece to see how this lays out with clarification, because this will not only substantially change how we have to educate our clients and our constituents, but it also is going to change a lot of how pool trusts are being administered and what advice and services they're able to provide to people as well.
Just one quick example. Think about if you're living in your home, you have to pay property taxes and you have to accumulate enough money in the pool trust in order to pay that property tax bill when it comes due. these rules are going to need some clarification, and we're hopeful that they will give some exemptions to the use of funds that are otherwise done on a quarterly or an annual basis and just accumulating for use for those particular purposes.
So we have our rule of halves, right? We always talk about this typically with a nursing home context. This is one of the biggest tools we have in our toolbox to save some money when you haven't done any previous planning and need a nursing home and you need it now. So we've kind of adjusted our slide a little bit because we can't even say we save half, we lose roughly half. That's typically how it works out with a nursing home because the numbers are much different. So with the rule of halves, we're trying generally to take a certain amount of money, gift it away, create a penalty period on purpose. And then to cover the penalty, we take a loan and we use the loan to pay during the penalty period. The question is, how is all this going to work in a home care context? Because to say it's complex is kind of a little bit of a misnomer, I think.
So we're going to go quickly through a case study. You'll have the slides, you can follow it through. But this is Bob, who lives at home with a $4,500 a month income, $280,000 of non-exempt assets. And again, IRAs, retirement accounts are exempt for both nursing home and home health care purposes. You have to draw on them to get them exempt. Now you have to maximize the income from those retirement accounts in most counties, but they're exempt. So we're talking about non-exempt assets of $280,000. Home health care costs $9,000 a month, $108,000 a year, 12 hours of help per day at $25 an hour. And there's the math, right?
So then we have him pay some down some expenses. So we prepay his burial, we buy him some stuff, he pays his legal fees. So we spend him down 30 grand.
And spending is not gifted.
Correct. Spending is fine as long as we're spending on Bob. And in this instance, we spent all that money on Bob. So we spend him down 30 grand. So now he's got 250,000 of money that's at risk. And then we have him keep 20,000. So we get him comfortably below the 31,175 asset limit. We gift away 158,820 to a Medicaid asset protection trust. And we have a loan made for about 71,000 and change to his son, all right before this all is supposed to happen in 2025. So what does this ultimately result in? So we wanted to kind of break this down. So we have his income right up top. So if you take his income of 4,500 a month, he gets his 1,752 allowance. That means that he nets 2,748 per month. So if you look at just his home care costs is $9,000 a month. We take out the money that then he can use from his income, so that's 2,748. So we're short 6,252 per month just to pay for his needed home care. We then looked at his assets. We started with 280. We spent 30. We then kept 20 with him because we got to get down below 31,000. So our at-risk money is that 230,000.
And although nursing homes may go up a percentage point here and there on an annual basis, home care costs vary widely.
Yeah. So just to kind of see where these numbers come in, right? So that gift that we gave away, that 158,820 of gift, that results in that 12-month penalty. And then that loan, we have it structured. So over a 12-month period, a loan for $71,180 would result in a payment of $5,931.66. If you pool that with his income, that gives him a total monthly income just of about $8,700. Just below his 9,000 needed for home care. That's what we want. We have to be short right there. So we're very close. We're a little short. That's how all this works. So that gives him just about enough money to pay for his home care costs, and it gets all this penalty rolling. So he applies for Medicaid. He gets the 12-month penalty. So the penalty runs between July 1st of 25 and the end of June in 26. The promissory note payment for that $59.31, that runs the same amount of time. Then Bob becomes Medicaid eligible 1 year from when we do this, July 1st, 2026. It's a lot. So what did we save? We saved the money in his trust. We saved his 20,000 of resources. We prepaid his burial, his personal property. So we saved him about $200,000 and we got him home care within a year under these new rules. So what does he get after that 12-month penalty? Then Medicaid is going to come in and hopefully Medicaid is going to pay for those 12 hours a day of care. And then we have that trust in place where any money that's hiding out in that trust is fully accessible by his kids to use for his benefit as long as they use it properly. But then we have to talk about his income, right? Because we've now sheltered all of his assets within that trust. So what about his income? Then we still use our pooled trust, just like we've been doing now. 1752 or whatever the exemption happens to be will stay with him. His excess goes into his pooled trust, where then that trust can continue to make expenses or payments for his expenses just like they would now. The question that continues to linger, like we've been saying, is would these result in transfers and penalties to a pool trust? because of the changing nature of full trusts have been allowed with all their exemptions and their process because there hasn't been a look back period for home care during all this time.
So when we're looking at it, New York has created a waiting period for home health care about 4 to 6 months based upon the NIA evaluations. And we have now a budget that we have to try to figure out how to pay those expenses while we're doing this calculation with a variable number. So we're hopeful that the state will allow the family to maybe do a little bit more gifting and then use that money to pay those home care expenses and call it a gift back. So that's one way to get to the point where you have at least some semblance of rational planning so that you can pay for that care during the waiting period before Medicaid actually starts paying, and then have a budget that will get you to the target zone with regard to the expiration of your penalty and the exhaustion of the money that you've set aside to pay for care during that time period. So this is very much volatile. So think about building a bridge to Medicaid eligibility. And in the case of nursing homes, the bridge is pretty steady and sturdy, but we've just built a bridge where all of the pylons are in quicksand. So that the bridge could sink at any time based upon changes in cost, changes in needs, changes in that person's condition in the home.
Yeah, the biggest thing that worries me is while I was doing this example, just putting it together, you know, the way that we currently use promissory notes is completely dependent on the cost of care. And the unfortunate part is when you're at home, that's not your only cost. That's only the cost of your care. You still have your carrying costs for your house, your property taxes, food, clothes, all that kind of stuff. In a nursing home context, it's not that you don't have those other expenses, but they go down pretty dramatically because the nursing home is generally taking care of most of what someone needs. In your home, that's not the case. So when we do a calculation in this context, we still have to gear it really toward just the home care and medical cost of it to make the notes work and the calculations work. But you're not taking in the other expenses of that person. So there's got to be other ways to siphon money off to the side. So this was a slide that I know you and some other practitioners put together when you did kind of a more national webinar about the changes and what this was going to look like
4 years ago.
And it was just kind of the point of it really is just saying what we're saying now. You have that moving target, right? Where you have, and then you have this period of like self-pay, and you've got other expenses to take into account. And it's just the math is just entirely different just because of the whole nature of the whole context being entirely different when you're dealing with a home care scenario versus a nursing home one. So I'm gonna keep moving on. So this is what we're talking about, right? You have to look at the additional excess costs of what it costs to live in someone's home, right? And then we have these retransfers like Louis is talking about. So if the family does take some money, take it either from the trust and move it out appropriately, or they just have it off to the side, but then they turn around and use for mom and dad. If they use for those benefits, will the county credit those back to then lessen penalty periods, which currently under a nursing home context, they usually do. But this is kind of a whole new world.
So we think there might be a slush fund in our calculation, in our formula, to have funds available to private pay and use it as a gift back, which will adjust the calculation on an ongoing basis. So there are four things that we have kind of identified out of the gate that we can do. The promissory note strategy, which is something that we do all the time for nursing home care. You don't have to spend it all down to $31,175. You can gift some, loan some, use the loan to pay back, and that's what's going to be applicable for home care. Again, it's quicksand in terms of the variables that go into that equation. Gift 100% of the excess resources with a gift back, which is something that I know practitioners do. You can self-pay for the 30 months and just ride it out. Say, I'm going to private pay 30 months. Make sure your trust gets funded so all your assets are protected. And at the end of the 30-month time period, you're going to wait it out and just get eligible at the end of 30 months. And then we always have spousal refusal and the ability to have a spouse with more assets than the allowance and to file a spousal refusal for income and assets that would take those off the table. So these are the things that we will be doing as attorneys once these rules kick in. But the next slide is even more important, and that is have your clients get ahead of the game. Start the trust planning now. The trust, even though it says irrevocable, it can be done very, very flexibly. And we have, I think, 1 or 2 prior Medicaid Monday presentations. If you want to get the intricacies of a Medicaid asset protection trust, you can go to our website and find the Medicaid trust webinars that Frank and I did with regard to explanations on how that trust works and how flexible it can be for the family to get a head start on this. You don't want to be applying for Medicaid the day you realize that you need to do planning. You want to do the planning first.
Couldn't say it better myself. So next month, we're going to talk about another thing that's up in the weeds, or up in the air in the weeds. That's the consumer directed personal assistance program and what we know about that, because as Lou already mentioned, that is looking to change pretty substantially as well. So that's going to be next month on Medicaid Monday, but we're going to do it on the third Monday of the month because we do have Indigenous Peoples Day on the second Monday. So we don't want to put people in a position where you have to choose to come see us on the holiday. So third Monday of the month for October. So that's October 21st.